It doesn't say on air. Doesn't it normally say on air?
Yes.
Oh, now it does. Okay, there we go. All right, good evening. My name is Kristen Ike. I'm the Code Enforcement Special Magistrate for the City of Deltona, and I'm calling the Special Magistrate hearing of November 25th, 2025 to order. The first thing on the agenda is roll call, so I will have all the code compliance officers introduce themselves.
Renee Kearney, Code Compliance Administrative Supervisor.
Danny Ron, Code Compliance Manager.
Sharon Shivers, Fire Marshal.
Jessica Cotterman, Hearing Clerk.
Todd Mead, Code Compliance Supervisor.
Hector Centeno, Customer Service Representative.
Jeff Scott, Code.
Hold on, there we go. Next on the agenda is my statement about how the hearing is going to proceed this evening. I am going to read this so I don't forget anything. We are here tonight because the City of Deltona has contended that there are violations of the Deltona City Code that exist. This is a public meeting, which means that no general public comment will be accepted, but each of the respondents and the code enforcement officers here tonight and any witnesses each of you call will be able to present evidence to me regarding each case and the violations of the Deltona City Code that are being alleged. I am an attorney and appointed by the City Commission to render decisions in these code enforcement cases to determine if a violation of the City Code exists and what fine will be imposed, if any. If you are here for a Massey case, you might see that next to your case number on the agenda. That means that I will be determining solely whether you have come into compliance in a timely manner in accordance with the previous order the special magistrate issued in your case, and will not be reopening the case to determine whether or not a violation existed in the first instance. Any decision I make this evening will be put into a written format in the form of an order. A copy of my written order will be provided to the city and then mailed to you as well. It is important to note that for any order I issue, you may appeal by filing a written notice of appeal with a circuit court within 30 days of the execution of my order pursuant to Florida Statutes Section 162.11. The procedure of the hearing today will be governed by Chapter 162 Florida Statutes. Formal rules of evidence shall not apply, but fundamental due process shall be observed and shall govern the proceedings. Hearsay is admissible, but only to support other competent and substantial evidence. If you are a respondent, you will be able to testify, tell me what you think I need to know about your case, and present evidence and witnesses. Your testimony will be under oath, so I will be swearing you in, and this hearing is being recorded. For each case, I will call the case number, and the city will proceed first. The city has the burden of proving that the code violation exists, and then you will be allowed to respond. For each case, I intend to admit the case file and the PowerPoint presentation. You should have received a copy of the case file when you came in this evening. If you did not, please let me know when I call your case. I will take the cases in the order that you signed in generally, first come, first served. And I do have, let's see, one case to announce that's been continued, which is Fire 046 2025 2031 Saxon Boulevard, Suite 110. If you're here for that case, again, that's Fire 046 2025. Then you do not need to stay. We will not be hearing that case this evening. I will go ahead and swear in everyone who intends to testify today as a group, which includes the code compliance officers. So if you're able, please stand and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? If so, please say I do. Thank you. All right. I have no ex parte communications to disclose, and so we will go ahead and get started with the cases. Thank you. First case is DEL 25-104, 1211 Abigail Drive.
My name is Steve Brockoff. I'm employed with the City of Deltona as enforcement officer. This will be case number DEL 25-104, City of Deltona versus RDG Investments LLC. Property address is 1211 Abigail Drive in Deltona. Parcel ID number is 8130-0548-0140. This is a violation of City of Deltona Ordinance Section 66-19, subsection 3, improper parked trailer, RV, boat, which states that boats, trailers, recreational vehicles should not be parked or stored within either the public right-of-way or within the portion of the lot lying across the full width of the lot between the front lot line and the frontmost part of the principal structure. Statutory requirements for this notification of hearing have been met by a notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed at the property appraiser's records. Both notices were posted at City Hall and the property at least 10 days prior to this hearing. In addition, both notices were sent to the registered agent, which is Michael C. Berry, at his address at 916 Shorecrest Avenue, and posted on the door at that address. All evidence in this case, including photographs, have been marked as exhibits and submitted to the code board clerk. I certify that any and all photographs be true and accurate portrayals of what I observed the day that they were taken or obtained via public records. In this case, began October 6th when I noticed trailers improperly parked on the vacant property. The property is well groomed, but it was cleared without a permit, but is still considered an undeveloped property. Since there had been a previous case, I posted notice of violation with a compliance date of October 15th and requested certified mailing. On October 22nd, I inspected and found the property still be in violation, and October 27th, I requested this special magistrate hearing. To date, the property is still in violation. I consulted with the assistant building official and the director of zoning and ascertained this information. Parking of any vehicle is not allowed on any property without an approved site plan. This is Ordinance 66-8, subsection 1. In order for this property to be in compliance, the owners would have to submit a site plan with engineer's drawings for the construction of a dwelling, have the plans approved by the permit department, construct the home, including a permitted driveway, have the property inspected and acquire a certificate of occupancy, and then the owners would be able to park up to 3 vehicles behind the front face of the principal dwelling. I also was informed that legal access to a vacant property, especially in residential areas, such as driveways or easements from other properties, would not be approved. So there's no legal access to go on to vacant properties. The city requests the property be found in noncompliance and given 7 days to come into compliance, or a fine of $75 per day be imposed. The reason for the $75 is we want to make sure that the fine's not low enough that it would just be considered storage price. And as a caution, I was hoping the owner or agent was going to be here because I believe the pickup truck might also be on their property. And if it remains, then the city will litigate against that in the future.
You said $75 and how many days?
7 days. All they have to do is go over there with a truck and move the trailers.
Okay.
But
What-
since he's here, are you thinking this is mailed to
Oh,
him?
you
Then
mean
the
with
city
7 days?
would be, the city could stretch the 7 days beyond that, so to make sure that the agent and the property LLC receives the order.
Yeah, okay. I wasn't there yet. I was still thinking about the section that's cited here. Obviously, these trailers are not parked within the right-of-way, and there is no portion of the lot where there is a principal structure.
Exactly. And that is why
So-
the vehicles will never be able to come into compliance with the ordinance, because there's no structure on the property. The only other way would be to remove the vehicles.
But, well, I mean, I feel like this section assumes that there is a principal structure. I mean, is this a residential neighborhood?
Yeah, if you go to, this is zoned residential, and
Yeah.
you'll see the blue indicating the property. And the idea is residential areas, there's, just because you own a property doesn't mean you can do anything you want to it.
Of course.
Even if you flew these vehicles inside with a Chinook, they're not supposed to be parked there. And they are violating the ordinance because they're not parked properly. They have to be on a property that's got a site plan that's been approved with a structure on it, principal dwelling, because this is a residential area, it's not
Yeah.
commercial area. If you can't park it behind a dwelling, they're in violation.
I am, do you happen to recall, because I believe we had one case before where maybe it was Mr. Scott that brought it, that had the dump trucks or something that were on the property. Do you recall that? Yes, I do. Was this the section that you cited? Do you recall?
No, I use commercial vehicles. It was 6618.
Yeah. I find this to be a strange citation. Give me one moment. Is there a reason that you did not use section 66-18?
Our program is, it was easier to cite the trailers being parked improperly, because at the first time, you'll see the first picture, there was like 4 trailers there. It's easy to generate in the field, the posting, because it's in a drop-down. The one that basically states this, that it doesn't have a site plan was not in the drop-down. Once again, these trailers, unless they're parked behind a house, they're not in compliance.
Well,
Ma'am, I would like to
I
continue.
have to, I mean, I agree that 100% that under the code, this would not be permitted. I'm not sure I agree that this is the correct section, because it's saying you shall not be parked within a public right-of-way and not parked within that portion of the lot lying across the full width of the lot between the front lot line and the frontmost part of the principal structure. So the prohibition is on parking in a certain area, and that area doesn't exist in this
Exactly
circumstance.
why they cannot be there. There is no principal structure. This is not a developed property. There's no way legally that these vehicles are supposed to be there. They have to be parked behind a structure. If you do not have a dwelling on your property, you cannot use your property for storage of your vehicles.
Yeah. Well, again, I guess I just disagree. I think that the section is saying you may not park in a certain area, and this area on this property doesn't exist, so there's no violation, in my opinion, under this section.
Your Honor, would like to continue this case.
Yeah.
Well, actually, My recommendation then is we get the section that it doesn't have a site plan in the drop-down, so I'll post it with that there's no site plan, and there is no parking allowed at all on any property that does not have a site plan. And once again, I talked to the permit department zoning. You can't get a vehicle in here legally. You can't access the right-of-way without a right-of-way use permit. And I know that I guess it's the parents of the girlfriend lives next door, but in order to do that, they would have to have an easement that would allow them to drive from that property, and that would not be allowed either. There's no way that these vehicles should be on the property, period.
I don't doubt that. Like I said, my concern is I think the section that was cited, I don't think is the correct one. I'm definitely concerned looking at this. Obviously, this is a huge eyesore.
On the
so
city's-
I agree, but
The city's viewpoint is, are they parked behind a dwelling? So they can't, the front, there is no principal structure, so they can't be there at all. But if you'd prefer that we bring this to the January meeting, then we'll post it with a different ordinance.
I think that would be needed. As I already explained, I think the issue here is that it's a prohibition. This is not saying where you can park. This is saying you may not park in a certain area on a lot. And that area does not exist
Which is
here.
why they shouldn't be there. But if it pleases the special magistrate, we'll post it with a different ordinance and
Okay.
be back in January.
All right. Well, we will go ahead and continue this then.
Okay, thank you.
All right. The next case is DEL 25-105, 706 Leeward Drive.
All right. All ready? Okay. I'll read this. My name is Todd Mead. I'm employed as a City of Deltona Code Compliance Officer. This will be case number DEL 25105, the City of Deltona versus Alex J. Alcivar and Linda N. Castillo. The property address is 706 Leeward Drive, Deltona, Florida. The parcel ID number is 813-019-070-210. This is a violation of the City of Deltona Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 304.1, which states the exterior of a structure shall be maintained in good repair, structurally sound, and sanitary as to not pose a threat to the public health, safety, or welfare. Corrective action of said violation is to repair, replace, or maintain in good repair any exterior surfaces, in this case the roof, obtain permits if required. The statutory requirements for notification for this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with a property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All the evidence in this case, including the paragraphs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. I'm reading this case in for a former officer who worked the case when he started, and so I helped work in the last few months on the case.
Okay.
This case was opened in January 21st of 2025 by a code officer after observing the roof of the home containing a tarp-like covering. The officer set the next inspection to be 60 days out from this date. On March 30th of 2025, the officer conducted another inspection at the property. The white covering was still present on the roof. The officer attempted to make contact with the homeowner. No one was present, so a door hanger notification was provided. The next inspection occurred on April 14th. The officer noted the roof was still completely tarped and would proceed posting a notice of violation and a certified mailing be sent to the owner of record. The homeowner contacted the code officer on the next day. The homeowner was able to leave a voicemail with the officer about the case. The officer learned through the homeowner that they were in litigation with their insurance company on a claim. The homeowner asked for an extension. The homeowner contacted the code officer again in May 6th of 2025 and left a voicemail. Again, a request for a continued extension on the case was mentioned. The Code Compliance Department received a call on the 14th of May from a legal representative for the homeowner. An email and letter stating litigation was in the process for the home were noted on the case. The letter was received by fax and added to information on the case. This letter is contained in the exhibit packet as well. The code officer continued with inspections on the property June 1st and July 14th. The tarp was present each time that it was observed. The case proceeded to a special magistrate hearing in the coming months. On September 21st of 2025, the homeowner was contacted again at the home and to note an update on the case. I, as the officer, provided the information with the homeowner for contacting the Housing and Community Development Department with the city to help and aid in process of seeking out some financial help. Information on the programs were provided to the homeowner. Next inspection was set for November 3rd of 2025. Notice for hearing was posted on November 9th. I spoke with the homeowner again and helped with the steps to meet compliance on the tarped roof. The homeowner did mention that he did attempt to make contact with the housing department, but have not received a call back from them. The city would like to request 90 days for the property to come in compliance or a fine of $50 per day to be imposed until such time that the property owner has notified the city of compliance.
Thank you. So that white, I guess it's like a plastic covering?
Yeah, I would call it like a vinyl tarp.
Vinyl, yeah. And it covers the entire roof, correct?
Yes.
Okay. And,
So
okay, the property owners are here?
Yes.
Okay. Hello. Can you state your name and address for the record, please? Okay.
Alex Alcivar.
Linda Castillo.
Okay. And what would you like to tell me about the case?
My insurance no want to pay for the chain, the roof, and the window too.
That they're not going to pay?
No. My lawyers sent to the papers to the city of Deltona. You can see.
Yes, Mr.
Okay.
Okay. Okay. Okay. There's nothing in the letter that indicates any kind of time frame in which they believe that, the litigation will come to a close. Do you have any idea of when that might be?
No, I don't have no idea. ¿Qué tiempo dijeron más o menos?
En el documento dicen que no saben.
No, they say
Yeah.
they don't say nothing to the times, nothing.
Well-
Only say wait.
Yeah. Well, unfortunately, this case has been open since when?
January of 2020, so almost 10 months. That's earlier
Yeah.
this year, started
Yeah.
initial.
And so, I understand that you're attempting to, make the claim against the insurance company or litigate the denial. But ultimately, it's your responsibility to maintain the property in accordance with the code. So while I sympathize that it takes some time, we've already had it almost a year. And the city has asked for 90 days. So I believe that is a sufficient amount of time. Is there anything else you'd like to tell me before I make the ruling?
I'm sorry,
No.
I don't understand you.
You didn't understand?
No,
Danny, will you kind of help with what I just said?
And can you repeat what you said? So I can-
Basically, I said that the case has been open for almost a year now.
que el caso
And-
está casi un año abierto.
Sí.
And ultimately, it's their responsibility to maintain the property in accordance with the code.
Y es la responsabilidad de los dueños de la propiedad que está encargado de la propiedad,
Sí,
está por los cados de la ciudad.
Okay.
And I said, I sympathize that there is litigation going on, but we can't,
Ella
allow
lo
it to
siente,
continue.
ella entiende su situación, pero ella tiene que dar una decisión con este caso.
Okay.
Pero
All right.
¿nos daría más tiempo o...?
Ella va a dar más tiempo.
Okay.
He's asking, are you giving more time? And I said, you will be given more time.
I will give 90 days.
Ella va a dar 90 días antes que la multa comienza.
Okay.
¿Y eso nos van a dar un documento ahora o nos van a enviar un documento después?
Eso le vamos a mandar. He's asking, are they going to get a document? Yes. After
Yes.
you sign the order, we will give you, le vamos a mandar por correo a copia de la orden que ella presentaba hora de noche, de los 90 días.
O sea, nos dan 90 días es para sacar ese plástico blanco.
Todd, if they remove the tarp, they're in compliance? Is that what it is?
Yes, that would,
Sí, sacando lo que está cubrido.
Puesto un cover, claro.
Yep. They ask if, to come into compliance, they would have to move the tarp, or, yes.
Yes.
Yo hablo siempre con los abogados y ellos lo que me dicen es que los procesos, de este tipo de procesos, demora de un año a año y medio. Pero ¿qué pasa? Que cuando el plástico lo pusieron incluso antes, ahí dice enero, pero lo pusieron un poco antes, pero ellos dicen que el proceso legal en sí apenas lleva, creo, 6 o 7 meses. Entonces como que dan a entender como que podrían faltar, no sé, medio año más, un año más. Entonces yo siempre ando llamando.
Yeah, the information he's getting from attorney is saying the process can take 7 months, and he's constantly calling the attorney to get the information. Pero como aquí están diciendo que ya casi un año y nosotros tenemos que hacer algo, okay? Pero seguro, I'm going to tell him also that con ese documento, you can darle al abogado diciendo, hey, mira, la ciudad va a comenzar una multa y si no se hace nada. I did mention to them that with their order, he can present that to the attorney. Maybe they can expedite the request
Yeah.
on their part. Okay?
Thank you.
All right. Okay. I'm going to go ahead and make the ruling. I find respondents in this case in violation of the city code as charged, and that respondents correct the violation before 4:00 p.m. on February 23rd, 2026, which is 90 days. In the event respondent does not comply by this date, a fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. The respondent is further ordered to contact the code compliance inspector to verify compliance with this order. I'm omitting the case file and PowerPoint as exhibits, as well as there's a new letter, actually 2 new letters, from the Florida Insurance Law Group. One is dated May 13th, 2025, and the other is dated November 25th, 2025. May I keep these letters?
Lo puede ella coger esa copia que lo puede.
Yes. Okay. These also are going to be added to the file as exhibits, and I find the notices properly given in this case.
Okay. Ella dio 90 días para la fecha de febrero el 23 de 2026
Okay.
a las 4 en la tarde que se arregle el CADO,
Okay.
el problema con el CADO de la ciudad. Que ella ha aceptado todos los documentos, hasta los documentos que usted presentó para ella, y lo puso en el folder para el caso.
Okay, thank you.
¿Ok? Eso es todo.
No, ¿y ahora ya
¿Nos podemos ir?
Good.
That's it. Thank
Sí,
you.
eso es todo. Gracias.
Oh, gracias.
Thank you.
Thank you. Thank you.
All right, the next case is Fire 028-2025, Massey case. Oops. Go ahead.
Good evening.
Good evening.
For the record, my name is Sharon Shivers. I'm employed by the City of Deltona as the fire marshal. This will be case fire 28-0025. The City of Deltona versus Stafford Enterprises Ltd. and K.A. Crawford LLC. The property address is 1644 Providence Boulevard, Deltona 32765, and the parcel ID is 813-014-60010. This is a Massey case. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what was observed on the day they were taken. This was initially a case for a violation of Chapter 42, Article 4 Fire Codes, Chapter 42-186, which adopts the latest edition of the Florida Fire Prevention Code. In specific, the Florida edition of NFPA 1, Chapter 1.7.12.10, which states no construction work shall proceed until the AHJ has reviewed the plans for compliance with the applicable codes and standards and the applicable permits have been issued. And Chapter 14.4.1, which states means of egress shall be continuously maintained, free of all obstructions and impediments to full instant use in the case of fire or other emergency. It was ruled on July 23, 2025, that the property owner was given 30 days to comply with violations A and D, and 90 days to comply with violations B and E. The violator did come into compliance with violations A and D. However, the violator did not come into compliance with violation B, as they did not obtain a permit for the construction of the new interior walls, and violation E, as the newly constructed walls are still obstructing the egress door. The property has been receiving a fine of $100 per day since October 22nd, 2025, and as of today, the property has accrued a fine of $3,400 over 34 days. The city is requesting that the fines continue at $100 per day until such property owner has notified the city of compliance, and compliance is verified by a fire safety inspector.
Thank you. Property owners present? All right.
Yeah, he's the tenant.
Okay, all right.
Hi, my name is Kushal Patel. I'm the tenant for the 1644 Providence Boulevard. So the guy who was working for us, he passed away last week, but we did submit the permit for the wall and fire. I do have permit number if you guys want it.
There is a permit?
Yes.
Is that,
As of this afternoon, I didn't see a permit number, so if you have that permit
It's-
number,
yeah.
I'll jot it down.
BLDC 25-0174.
I'm going to are you able to look it up?
Yeah, I can.
Can you repeat that permit number, BLDC?
BLDC 25-0174.
Do you know when that was submitted? did he say?
No, because I just talked to the lady, the general contractor. I just told her if you can give me a permit number. She just
Okay.
sent it to me.
So if it is submitted, it hasn't been reviewed, it would still need to be reviewed and issued and finals and done before we can stop the case. But we'll look into it and see if
Okay.
it's been issued or at least submitted.
Is this one for 1878?
No, this is 1644 Providence.
1644.
It was submitted today, online.
Good.
Yeah.
Perfect, okay. So I am here tomorrow.
Okay.
So if it is in the system and ready to be sent to a reviewer, I'll go ahead and review it. I don't know if it'll be approved, but I'll at least start the review.
Okay. Yeah, no problem. Yeah.
Okay,
Do I need to pay fine or anything?
not yet.
Okay. Yeah, because the guy who was working, he's dead, so I have.
Yeah, unfortunately, about a week ago, we heard the news.
That's why I have to move everything.
The handyman that we believe constructed the walls, he was having a difficult time finding a contractor to accept the work, unfortunately passed away about a week ago.
Okay. All right. So a permit has been submitted but not issued, and then is this a picture of the wall that is obstructing the egress?
Correct.
Yes. Okay. So then, at this point, I am just determining whether or not you had come into compliance within the time ordered, which was October 21st, correct? No.
I believe the 20.
Yes, October 21st for violations B and E. So, and so, since there hasn't been compliance, the order is going to say that there will be a fine imposed based on what I previously ordered. So as of right now, as Ms. Shivers said, this is at $3,400, and each day it is $100 more. So I encourage you to try to come into compliance as soon as possible.
Yeah.
Is there anything else before I make the ruling?
So is it gonna be fine for 3,400 plus $100 a day?
Yes. Yes.
All right.
Okay. All right. I will go ahead and make the ruling. I find respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance. I'm admitting the case file and PowerPoint as exhibits, and I find the notices properly given in this case.
I got a question. Is it only fine for the wall or plus electrical too?
No, the electrical has come in, that's violation was not presented because that's come into compliance with the permit being issued and the fire alarm we took care of.
Okay.
So this is just for the construction of those walls.
Okay.
All right.
Thank you.
Thank you.
I can ask, can you do me a favor? Because I know it's been violation, I understand. But if the guy who was submitting, he passed away, he was in hospital. That's why I cannot have to move to the other person and look for everything. If it's been there, he would have submitted before.
I mean, I understand that there were some circumstances here. However, this order was from July.
Yes, I understand, but he was working with it because with the electrical and everything, we were doing one by one step, but he was also having a heart issue. So that's why he already had one surgery, and then by the second surgery, he passed away.
Yeah, I mean, I generally don't change the orders once I've already made them. And
But if you can do like a minimum fine or something, I mean, like a 3,400 would be much more.
I mean, I think that there was a lot of time given for this, so I'm not going to change the fine in this case. If it becomes, you're certainly welcome to request a lien reduction, but that would be the property owner. You're the tenant, correct?
Yes.
I mean, this is.
She don't listen to us anymore. That's why I have to go
Yeah.
each and everything. And I have 3 months old baby, which is going rough with me. Everything is back and forth with the hospitals and everything. And still I got a leg surgery now.
Well, like I said, I provided quite a bit of time to come into compliance for this, so I'm not going to change the fine at this
It's okay.
point. And to the extent the owner, the property owner, would like to request a lien reduction, that avenue is available to them.
She not gonna listen to me. It's okay. I will just pay the fine. That's
All right,
That's
all right, thank you.
Thank you.
Thank you. All right, the next case is DEL 25-076, Massey, 858 Leeward Drive.
All right, okay. My name is Todd Mead. I'm employed by the City of Deltona as a Code Compliance Officer. This week, Massey case number DEL 22076. The City of Deltona versus Jose J. Lopez and Lucia Hernandez de Lopez. The property address is 858 Leeward Drive, Deltona, Florida, 32738. The parcel ID number is 813-017-090110. Statutory requirements for notification for this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with their property appraiser's record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what observed on the day they were taken. It was ruled on July 23rd, 2025, that the property owner was given 60 days to comply. The owner did not come into compliance within those 60 days and has been receiving a fine of $25 a day since September 22nd, 2025. As of today, the property has accrued a total fine of $1,625 over 65 days. The city is requesting that the fines continue at $25 per day.
Okay, you said 1,625?
Yes.
Okay. All right, and then, okay, is this the picture from today?
This is there's a couple of pictures right there. This fence is still in disrepair here on this side of the house, the boards, but missing partial panel, and this side, given that the posts are still there, it's still considered in disrepair because he have not replaced any panels or removed the post to come into compliance.
Okay. Thank you. Anything else before I
that's
make the
it.
ruling?
That's all.
I find respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order, and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code compliance inspector. Respondent shall notify the code inspector to verify compliance. I'm omitting the case file and PowerPoint as exhibits, and I find the notices properly given in this case. Thank you.
Thank you, Your Honor.
Next case is DEL 25-100 A and B, a Massey case, 1838 Joyner Drive.
Good evening. My name is Bashir Turkzi. I am employed by the City of Deltona as a Code Compliance Officer. This will be Massey Case Number DEL 25-100 A and B. City of Deltona versus Julia M. EST Vento. Property address is 1838 Joyner Drive, Deltona, Florida, 32725. Parcel ID number is 813053190070. The statutory requirements for notification of this hearing have been met by the notice of hearing and the notice of code violation being sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. It was ruled on 10/22/2025 that the property owner was given 14 days to comply. The owner did not come into compliance within those 14 days and has been receiving a fine of $50 a day since November 5th, 2025. As of today, the property has accrued a total fine of $1,000 over a period of 20 days. The city is requesting that the fines continue at $50 per day.
All right, thank you. Okay, so this is the picture of the pool. It's hard to tell whether it's been, is that today?
No, that's not today. As you can see the puddle of water that's still on the tarp that's been placed on the pool.
Oh, there's a tarp on it. Okay.
Yes, they put a tarp, but in order to come into compliance, the pool has to be either cleaned or emptied.
Mm-hmm, yeah, okay.
Yeah.
And then and this is the picture of the
This is
of the
today's,
vines.
correct.
Yeah, okay. All right, anything before I make the ruling?
No, that'd be all.
Okay. I find respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance.
Good evening. My name is, excuse me. My name is Jeff Scott. I'm employed by the City of Deltona as Code Compliance Officer. I want to make an amendment to the agenda and the notice of hearing. The property owner name was missing the middle initial S, but the notice of violation has it, and the notice was sent to the proper address with the property appraisers.
Okay, thank you. That, you're saying that was on, it's on the agenda?
Yes, ma'am, in the notice of hearing.
Okay,
Okay.
go ahead.
This will be case number DEL 25-089, City of Deltona versus Deborah S. McGee. Their property address is 1556 East Normandy Boulevard, Deltona, Florida 32725. Parcel ID is 813-011-230-020. This is a violation of the City of Deltona's Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 303.1, which states that swimming pools shall be maintained in a clean and sanitary condition and in good repair. Corrective action for said violation is that the pool must be maintained either drained or of water, or water must be chemically treated to remove algae. Water should be clear and sanitized. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation was sent certified mailed to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. I certify all of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This case was opened as a complaint and started by another officer on December 31st of 2024 for a sanitary pool. On February 10th of 2025, the officer contacted the property owner, Ms. McGee, and explained the violation and corrective action. On September 2nd, 2025, I contacted both the complainant and respondent regarding this case. On September 9th, I posted notice of violation, and notice was sent certified via mail. On November 5th, 2025, I posted notice and hearing. As of today, the property remains in violation for the sanitary pool. The city would like to request 14 days for the property to come into compliance or a fine of $20 to $5 per day to be imposed until such a time that the property owner notifies the city of compliance.
Okay. So, yes, I can tell the pool is sort of green in color.
Real dirty.
I think what I would do, though, is I would say 21 days, which is December 16th. In the event respondent does not comply by this date, a fine in the amount of $25 per day will be imposed for each day the violation continues past the aforestated date. The respondent is further ordered to contact the code compliance inspector to verify compliance with this order. I'm omitting the case file and PowerPoint as exhibits, and I find the notices properly given in this case.
Okay.
Thank you.
Thank you.
All right, the next case is DEL 25-106, 685 Spreading Oak.
Ready?
Go ahead.
Okay. My name is Todd Mead. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 25106, the City of Deltona versus David A. Christina L. Steele. The property address is 685 Spreading Oak Ave, Deltona, Florida, 32738. The parcel ID number is 813-062-360-060. This is a violation of the City of Deltona Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 304.1, which states the exterior of a structure shall be maintained in good repair, structurally sound and sanitary as to not impose a threat to the public health, safety, or welfare. Corrective action for said violation is to repair, replace, or maintain in good repair any exterior surfaces, in this case the roof, obtain permits if required. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true, accurate portrayals of what I observed on the day they were taken. Excuse me. This case was again opened by another officer formerly with the city working. This case was opened on January 21 of 2025. Officer observed the home with a tarp. Officer set up the next inspection 60 days out from this date. On May 30th, the officer conducted another inspection at the property. The blue covering was still present on the roof, and the officer attempted to make contact with the homeowner. No one was present at the time. A door hanger notification was provided. The homeowner made contact with the Code Compliance Department customer representative on April 9th of 2025. The homeowner stated she is getting her roof replaced and has an open claim. The new inspection was done on April 21st, 2025. The notice of violation was prepared and posted on the front door, and the compliance date was set for May 21st of 2025. The officer conducted the inspection and found that the tarp still to remain on the roof. The officer did allow for an extension of time due to the insurance claim. The next inspection occurred June 23rd of 2025, where the tarp was still noticed to be present on the roof. Case was extended out to another inspection date of July 23rd of 2025. At this time, the roof was still noticed to be in violation. The case was updated on October 19th of 2025 with a photo indicating the tarp was on the roof and the violation was still present. I, as the officer reviewing the case, opened to make contact with the homeowner and left a business card for contact. I did receive a call from Mrs. Steele in October 21st of 2025, but it was just through a voicemail left with to me. Made an inspection on November 3rd and then documented the tarp on the roof. Notice of hearing was posted on November 9th. An attempt to contact the homeowner again, but there was no answer at the door. And the homeowner has only left a voicemail with me with the
The soffits or anything. It's difficult to tell.
Through a more in-depth inspection, there may be, but at this time I can't comment on anything
Okay,
going
I just
on.
want to make sure, so for purposes of compliance, we're talking about the blue tarp issue
Yes.
on the roof.
Just the
so.
tarp only, yes.
Okay, thank you. All right. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on February 23rd, which is 90 days. And in the event respondent does not comply by this date, a fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. Respondent is for violation continues past the aforestated date. Respondent is further ordered to contact the code compliance inspector to verify compliance with this order. I'm admitting the case file and PowerPoint as exhibits and find the notices properly given in this case. Thank you.
Yes, thank you.
This last one? No. Oh, yes. Oh, okay. Yeah, that one. Okay. Okay, I don't have that on my, on the agenda. Yes, all right, so the last one here is Fire 036, 2025, a Massey case, 1878 Providence Boulevard. Go ahead.
Ready? Yeah. For the record, my name is Sharon Shivers. I'm employed by the City of Deltona as the Fire Marshal. This will be case number Fire-036-2025. The City of Deltona versus Fast Lane 1878 Investments, Inc. The property address is 1878 Providence Boulevard, Suite T, Deltona 32725, and the parcel ID is 813-015-160-060. This is a Massey case. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was initially a case for a violation of Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the latest edition of the Florida Fire Prevention Code. In specific, the Florida edition of NFPA 1, Fire Code Section 1.7.12.8, which states the HJ shall be authorized to require permits for conditions listed in 1.7.12.2, 1.7.12.5, and 1.7.12.6 unless otherwise permitted by 1.7.12.9. It was ruled on August 27, 2025, that the property owner was given 45 days to comply. The property owner did not come into compliance within those 45 days and has been receiving a fine of $50 per day since October 14, 2025. As of today, the property has accrued a fine of $2,200 over 44 days. The city is requesting that the fines continue at $50 per day until such property owner has notified the city of compliance and compliance is verified by a fire safety inspector.
All right, and so this was for not getting a permit for a change of occupancy. I had from a retail to a mercantile? Is that
From
right?
a business to a mercantile to retail, yes.
Oh, okay, business.
And I thought I had the notes here. I believe it was August 20th. Around August, they had submitted for a permit. We did one review. Those comments were sent. We have not gotten a resubmittal. I know Captain Schaller has been in contact with them as of 2 weeks ago, where he was still trying to help them obtain that permit, but we just haven't gotten
Okay.
to the finish line yet.
All right. And you said it was a change from business, the occupancy was business to mercantile?
Correct.
Okay. I guess I want to make sure because I'll have to note that in the order because I put from retail to mercantile and I was questioning that.
Oh, yeah.
That makes,
The original order?
okay. Yes, so I'll make a note of that in the Massey order.
Okay.
All right. Anything else before I make the ruling?
No.
Okay.
That's it.
I find respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance. I'm admitting the case file and PowerPoint as exhibits, and I find the notices properly given in this case.
Thank you.
Thank you. Okay. Is that the last one? Okay. Anything else for the good of the order before we adjourn? No? All right. Happy Thanksgiving, everyone. Thank you.
Happy Thanksgiving.